What happens when a US citizen petitions for a family member, but then that petitioner unexpectedly dies before the immigrant family member becomes a permanent resident? That's what we're going to discuss in today's video. This is a topic that is very close to home for me because it affected my family specifically. Both of my grandparents were US citizens, but only my grandmother had filed family petitions for several of my aunts and uncles to move to the United States. Before those family petitions became current, she passed away. And with her, unfortunately, those petitions died as well. In fact, my family is now regretting not having filed petitions from my grandmother and grandfather simultaneously so that in the event that one of them passed away, the petitions would still survive and allow my aunts and uncles to migrate to the United States. The general rule when a petitioner dies is that the petition dies with them. But I'm going to describe two exceptions to this rule. The first one is when a US citizen petitions for a spouse, and the other one is for any other family category. The first situation I want to discuss is one in which a US citizen spouse petitions for his or her spouse while they're both living in the United States, and then unexpectedly or expectedly, the US citizen petitioner dies. In that situation, the best course of action we can often take is to convert the family petition into a widower's petition. It's called an I-130 widow petition. There are several things we need to prove, but that's beyond the scope of this video. Basically, the most important thing is that there will eventually be an interview where the surviving spouse needs to prove that it was a good faith marriage entered into for good faith, not fraudulent. Now let's talk about a slightly different scenario or fact pattern. Let's say a US citizen petitions for a family member who's living abroad, and then that US citizen petitioner dies. Well, that petition will be automatically revoked. Remember the rule, the petition generally dies with the petitioner. There is one exception to this. It's called 204L, and it has several requirements for trying to reinstate that family petition. The requirements generally involve proving that the beneficiary, so the immigrant who's trying to receive the immigration benefit, must have lived in the United States, resided in the United States. Doesn't matter if they're here unlawfully or with some other sort of status, they must be residing in the US, even if they're not physically present in the US on the date that the petitioner dies. That's not required. The other thing to keep in mind is that the affidavit of support, financial sponsorship requirements don't go away even if we can get the petition reinstated. You'll need a substitute sponsor, financial sponsor, anyone who's a permanent resident or a citizen who makes enough money and is willing to financially sponsor you. If we can show these two things, we might be able to get the petition reinstated so that you don't lose your old priority date or all the time you've been waiting for the petition to become current. I want you to take away two main things from this video. The first one is that there is a chance of having the petition reinstated if the immigrant beneficiary was residing in the United States. The second one goes back to my personal story. In my situation, we should have filed family petitions from not only my grandmother, but also my grandfather as a backup petitioner. Had we done that, my aunts and uncles would probably be in the US. But unfortunately, the petition died with my grandmother. And that happens all the time. So don't make the same mistakes that my family made. If you guys have questions about this topic or this video, please put them in the comments below. I'll be sure to answer them or use them for future video topics. Be sure to subscribe for more immigration news, and I'll see you guys next week for another video.